Barbara Kowalski was 71 years old when she moved her mother, Diane, into a nursing facility outside of Pittsburgh. Diane had dementia. She needed round-the-clock care. The facility cost $9,400 a month. Barbara's mother had about $18,000 in savings and a house she had owned since 1987, fully paid off, worth about $210,000. That house was where Barbara grew up. It was supposed to be her inheritance. Not a fortune, just the one thing her mother had to leave behind. Medicaid approved Diane's care within 60 days. Barbara was relieved. She thought the hardest part was over. Diane passed away 2 years later. 6 weeks after the funeral, Barbara received a letter. It was not a condolence card. It was a claim from the Pennsylvania Department of Human Services. Medicaid had paid $226,000 for her mother's care, and the state intended to recover that money from Diane's estate. The house, the only asset left. Barbara had 30 days to respond. She had never heard of the Medicaid Estate Recovery Program. Nobody at the facility mentioned it. Nobody at the Medicaid office mentioned it. The letter was the first time she saw those words. This is not a rare case. This is happening to families in every single state right now. And most of them, just like Barbara, never saw it coming. Here is the rule most people don't know exists. If you are 55 or older and Medicaid pays for your long-term care, nursing home, assisted living, home-based care, federal law requires your state to attempt to recover those costs from your estate after you die. That is not optional. That is not a state policy. That is federal law, written into the Social Security Act, enforced in all 50 states. The program has a name, MERP, the Medicaid Estate Recovery Program. What it can come after: your home, your savings, any asset that passes through probate, the house you paid off over 30 years, the savings account your spouse depends on, the one thing you plan to leave your kids. Here is the part that blindsides families the most. Medicaid does not take anything while you are alive. Your mother lives in her home. She qualifies for Medicaid. She gets care. Nothing happens to the house. Then she passes away, and the clock starts. The state files a claim against the estate. If the estate cannot pay, the home may have to be sold to satisfy it. Most families find out at the worst possible moment, while they are grieving, on a deadline, with no plan in place. This has been the law since 1993. So why are we talking about it now? Because the number of seniors entering Medicaid long-term care is rising sharply. Because nursing home costs have nearly doubled in the last decade, the national median is now over $9,700 a month for a semi-private room. And because the new federal budget legislation passed in 2025 cuts federal Medicaid funding to states, which means states are under more financial pressure than they have been in years to enforce every recovery they are legally entitled to pursue. When states need money and the law gives them a tool, they use it. Some states have always pursued estate recovery aggressively: Pennsylvania, Oregon, Iowa, Minnesota. Others have been more lenient. That is changing. As federal matching funds shrink under the new law, the states that were quiet about MERP are getting louder. And there is one more thing. Congress introduced legislation in January 2026, the Stop Unfair Medicaid Recoveries Act, specifically to end this program. It has not passed. As of today, it is still the law, which means every family with a parent in Medicaid long-term care right now is exposed to it. Not all states pursue estate recovery the same way. Federal law sets the minimum. Nursing home and home-based long-term care costs must be pursued. But some states go further and recover costs for almost any Medicaid benefit received after age 55. Not just nursing home care, regular Medicaid, prescription coverage, home health visits. If you live in one of the expanded recovery states and you are receiving any Medicaid benefit after 55, your estate may owe money back even if you never spent a single day in a nursing facility. The states currently running the broadest recovery programs include Oregon, Idaho, and several others. If you are in a state like California, recent rule changes have actually narrowed recovery significantly. The rules are not the same everywhere, and that matters. Here is the trap that catches families who think they planned ahead. A parent transfers the house to their adult child to protect it. They do it without knowing the Medicaid 5-year look-back rule. Any asset transferred within 5 years of a Medicaid application can be counted as a disqualifying transfer. The parent could lose Medicaid eligibility for a period of months or years, right when they need care the most, because of a transfer meant to protect the family. Good intentions, wrong timing, devastating outcome. There are real, legal ways to protect a home from Medicaid estate recovery, but they require time. That is the one thing most families do not have when the conversation starts. Move 1 is the Medicaid Asset Protection Trust. This is an irrevocable trust, meaning once the house is in it, you cannot take it back out. But the house is no longer in your estate when you die, which means Medicaid cannot recover against it. You can still live in the home. You retain the right to occupy it. You simply no longer own it outright. It has to be set up more than 5 years before a Medicaid application is filed. That 5-year window is not negotiable. The families who do this in their late 60s, before any health crisis, protect their homes entirely. The families who try to do it at 78 when a diagnosis arrives are usually too late. Move 2 is the caregiver child exemption. If an adult child lived in the parent's home and provided care that demonstrably delayed the parent's need for a nursing facility for at least 2 years prior to the Medicaid application, that child may be entitled to receive the home without it being subject to estate recovery. This is a real federal exemption. It is rarely explained at intake. The documentation required is specific: medical records, care logs, written statements. It must be established before or during the Medicaid application, not after the parent dies. Neither of these is a loophole. Both are written into federal Medicaid law. The difference between a family that uses them and a family that doesn't is almost always one thing: timing. You do not need to be in a crisis to take these steps. You need to take them before a crisis starts. First, find out which recovery rules your state enforces. Search your state name plus Medicaid Estate Recovery Program. Every state Medicaid agency is required to publish this. Read it. Know whether your state recovers only long-term care costs or all benefits after 55. Second, if you have a parent over 65 who owns a home and has limited savings, talk to an elder law attorney, not a general estate planning attorney, an elder law attorney, before any health crisis forces the conversation. The consultation typically costs a few $100s. The protection it can set in motion is worth multiples of that. Third, if a parent is already receiving Medicaid long-term care, ask the facility's social worker directly. Has a MERP claim been filed or is one expected? You have the right to ask. Get the answer in writing. Fourth, if you receive a MERP claim letter after a parent's death, do not ignore it and do not assume it is final. Hardship exemptions exist. Spousal protections exist. You have the right to appeal. You have a deadline, usually 30 days, so act immediately, but act with an attorney, not alone. The Medicaid Estate Recovery Program does not send a warning. It does not explain itself at the intake desk. Nobody at the nursing facility is required to tell you it exists. The letter arrives after the funeral, on a deadline, when the family is least equipped to deal with it. Barbara eventually found an elder law attorney who identified a partial hardship exemption. She did not lose the entire house, but she spent 8 months fighting a claim she never knew was coming for a program she had never heard of while she was still grieving her mother. The families who protect their homes are not the ones with the most money or the best lawyers on speed dial. They are the ones who found out about this program before they needed to. Now you have. If you have a parent over 65 who owns a home and is on Medicaid or may need it, share this video with the person in your family who handles the finances. Not tomorrow, today. Because the 5-year clock only starts when the trust is signed, and it does not run backward. That is what this channel is here to do. I'm Jake Briley. I'll see you in the next one.